Now Councillor Williams has joined us, I think we might be able to start the meeting. What do you think? Good evening, Councillor Williams. Good evening, everybody. Welcome to the Planning Committee. I don't have to tell you, but this is being streamlined or filmed and goes out to the public this evening. So welcome to members of the public. Can I remind everyone present that this meeting will be broadcast live via the internet and the record is archived for future viewing. Okay? Thanks for that. So, moving swiftly on, I want to tell you also that agenda item 12I, which I think you received as a late application, an urgent item for the chairman, that's not going to proceed tonight. I understand that there are a few problems with it and Marcus would like it to come to the January meeting. Anything to add to that, Marcus?
No, Chair. It's just to confirm that the plans need some work. There were some discrepancies in terms of different elevations, so I felt it'd be safer if it came to the January meeting. It is literally 2 weeks or so.
Yes, and we've got an elevations man here, so we better make sure we get it right. Right, okay then. Apologies for absence.
Thank you, Chair. Yes, we have received apologies from Councillor Eric Hacker, Councillor Mrs Audrey Preston and Councillor Ray Thomas.
Anybody else?
Yeah, Councillor Bird.
Thank you. He's running late, shall we? Okay. Thank you, Councillor Penrose. I know that Councillor Powell told me that he was coming, so I assume he might be running late. Minutes of the last meeting. Can members endorse that the minutes are correct and that I can sign them off? Thank you very much. To receive declarations of interest under the Council's Code of Conduct. Has any member got anything to raise? Deathly silence. I take it then there is nothing to raise. And we are being joined by Councillor Marnie. Thank you. Okay. Thank you, Councillor Marnie. Right, agenda item 4 is a reference for the local development plan, the process review consultation, which has come from Cabinet on the 1st of December. Marcus, have you got anything to add to that?
Thank you, Chair.
Agenda?
No, just to point out that this is a proposed amendment to the way local development plans are drawn up. The amendments mainly involved to increase and improve front-loading the local development plan process to speed it up, to reduce the stages required for LDP plan revision by introducing a shorter procedure for partial revisions to the LDP when there is not sufficient, the changes are not significant enough to warrant a full procedure, to amend the LDP soundness test to make it clearer and simpler, and to provide greater clarity on the LDP evidence base and the monitoring and review of LDPs. The key change that is proposed in these this consultation is that it removes the alternative sites process from the planning system, local development plan system, which I think has led to a lot of confusion with the public, with everyone really, and that's not just in this council's area. It's actually happened right across Wales, that the whole process has almost got gummed up and stopped at the alternative site process when you've already been through one sort of assessment of sites in the first place. So basically the proposal from Welsh Government is to remove that part of the process along with other tweaks and changes to make the plan process a lot simpler and more straightforward.
Okay, I think the report's just for noting, unless any members got any burning ambition to speak. Councillor Penrose.
Yeah, I don't have any main problems with the main meat of the report, but I do object and will be voting against based on the alternative site provision, because I do think this is part of democracy where residents should be consulted, and quite often it's an important part of the process.
It's an information report, so we won't be voting on it. But your comments will be noted. Councillor Marnie.
Can I just jump in on the same vein? I realise we're not voting on it. I mean, basically this means, what, was a bit of effort, a bit too much trouble for them, and they want to remove it. That's quite staggering, quite frankly. Staggering. I know you didn't put it together, Marcus. I'm looking at you as it happens. But
Marcus, come back.
I think the general view is that the LDP process does involve a number of stages where the public get involved and are consulted on allocations, policies. The alternative sites process actually is a vehicle for developers to suggest alternative proposals and alternative development sites. And what Welsh Government feel is that they've already had their chance on at least 2 previous occasions, and it's almost giving a third chance to slow up and confuse the public in many ways, because what's happened in the Vale, for example, is we've received over 2,000 various objections to alternative sites that have been put forward, many of which have absolutely no merit, and they've just been put forward by speculative developers. So it isn't really a democratic deficit, if you like. It's not leading to a democratic deficit. It's actually trying to remove a process quite often which is used by developers to try and bring sites into a plan where they've been already gone through the LDP process to be removed.
yes, but surely then the situation. So, my apologies. I'll just very quickly. Surely then the situation should be you ban or bar developers from taking part in the alternative site plan. The majority of those alternative sites, I'm quite sure, I may be wrong, has been put forward by the public, which is the whole point of the thing.
I couldn't comment on whether it's the majority. I think ultimately the view has been taken by Welsh Government that there are sufficient stages in the plan before you get to that stage where people can interact and get involved in the planning process, and that it isn't seen as a particularly helpful part of the planning process. And indeed, I understand that when they've reviewed the plans that have actually gone through the process and been adopted, the alternative sites process has added very little to the plans. So it's just a view being taken on trying to speed up the production and the coverage of local development plans across Wales.
I'll take Councillor James first, and then I'll take Councillor Parker.
Thank you, Chairman. I could see that it's caused a great deal of confusion because, as Marcus has rightly said, once we went to the alternative sites point in the LDP progress, there were lots of applications, and the council was obliged to consult again then on the alternative sites, having already gone through the process where it published a draft of its proposals. So I think it does lead people to be very confused about and get very upset about some of these sites that have been put forward that have no chance because they don't even meet the criteria of the strategy. So I think it's something that certainly the Welsh Government put into this LDP process that didn't exist in the UDP process. So to some extent they've learned their lesson, I think. And I could see that, you know, if there is an opportunity for people to put forward alternatives, it should be that it should be judged against criteria and not then published again. You know, I think, but there we are. The Welsh Government, I think, has learned from its mistake and has made a decision. So, thank you.
Thank you. Councillor Parker.
Yes, I believe I'm right in saying, and Marcus can tell me, that in fact in England it has been used as a device to delay LDPs and purely as a matter to delay the LDP. And as we know, if you delay the LDP, that allows for a lot of problems with sites coming in. And I know, certainly having read an article in the Telegraph in the last 2 weeks, there is a lot of concern on that.
Yes, you are quite right, Councillor Parker. In England, the process is slightly different, but it's similar. And it has been used actually by developers who've got sites in on other sites to actually try and make sure that the plan isn't adopted on time and they can get their proposals through the system. So, yeah, I'm sure that it's also been used by groups who are wishing to slow the plan up for other reasons. But in general terms, I think the view is that these alternative sites come in, they haven't gone through any sort of screening process, they haven't been through a sustainability test, they haven't been through anything at all which actually assesses their merits. They get the council is duty bound to consult neighbours on these schemes, and a lot of the neighbours and people involved, as Councillor James said, got very, very concerned about some of the proposals and very upset, and were ringing the council. And actually, it's very difficult for officers, because officers are saying to them, well, these aren't our schemes, we've not put them forward, you know, these have been put forward by X or Y. We can't even say they've got very little likelihood of success, because we can't prejudge them. We just have to say they are being considered as alternative sites as part of the alternative sites process. So it isn't helpful. It doesn't really add to the process in any way, shape or form. And it is something that was added on top of the old unitary development plan process. It was thought it would, if you like, legitimise it, and all it's ended up doing is confusing people and upsetting people. And actually, because the LDP process is supposed to be more streamlined in any event, it just elongates a process and confuses the public as to what's actually in a plan. Who has this site come from? Has it been suggested by a developer? Has it been suggested by the council? Has it been suggested by your neighbour? It doesn't add very much to the process, and I think it's probably, as an officer, my view is it served little purpose and just really delayed the whole process.
Okay, Councillor Penrose again.
Thank you, Chair. Only a brief point. I think the reality of LDPs is quite often some things are put in the LDP pretty well last minute or go unnoticed by residents. And of course, I agree with you that we can't just have people offering alternative sites on a whim. And I think sustainability reports, the criteria should be made that if an alternative site, and sometimes they can be good suggestions, but basically speaking, they shouldn't be just a whim, that it should be with full report, with backup, what consideration's been given. And I feel that the Welsh Government could be guilty here of throwing the baby out with the bathwater. You know, I agree, cut down the ones that are whims, but I think the serious ones do offer alternatives. And I'm deliberately not going political, I'm deliberately not picking sides, but basically speaking, I think there are cases where it could be looked at. Certain things could be looked at, but the report should be afforded with it, and it's not just a one-liner saying, I nominate this site, you know. But that's just my viewpoint.
Okay. Nothing else to add, Marcus?
No, Chair.
No. It is a for noting report, so if we note it, we can move on. Okay, thank you for that. Agenda item 5, I think this is for noting. It's a public rights away, which was held on the 24th of November. Two of the councillors are certainly, three of the councillors are certainly here. I've got nothing to add to the report. It will get approved at the next PROW committee, but it's just brought here for your noting. Members happy to note it? Yeah. Thank you. Agenda item 6, these are the building control matters determined by the director under his delegated powers. We've had these agenda and minutes for over a week now, and I don't know whether anybody wants to raise anything. Anybody? No? No. Move we note these. Thank you very much. So over onto agenda item 7, that's the planning applications determined by the director under his delegated powers. Anything to add, Marcus?
Nothing to add, Chair, no.
No, thank you. Any member? Councillor Drysdale, before we move them?
Just a question, Chair. On page 11, fifth from the bottom, the land east of Bondleston, the decision code is ER, which isn't in the key. What does it mean?
It means environmental impact assessment required.
There we are. That's a new one on you, Councillor Drysdale. If you'll note that on your list, please. Yeah, okay then. That being said, members happy with this report? Yeah. Move. Thank you very much. Appeals on agenda item 8. This is on page 22. Marcus, would you like to run through the appeals with us?
Thank you, Chair. Yes, there's only one issue or one appeal on here which is of major interest, I think, which is the land at Hawthorne Cottage, Tinnerodin, use of the land for stationing of caravans for residential purposes for one gypsy pitch together with the formation of a hard-standing utility day room. This actually is shown as an appeal which the council has lost, although if you read the various parts of it, the inspector agreed with almost everything the council said. He agreed that the distinctive rural character of the area needed to be preserved. He agreed that the new development will affect the special landscape area, and he agreed that it was a green, the land was in the green wedge, and it was very important that the green wedge was protected. He then went on to say that he did not feel that the proposal itself overrode the substantial weight against the proposal attached to the fact that development is inappropriate within a green wedge, and that there is additional harm arising from the proposal on the openness and character and appearance of the area. He did not feel that the actual character of the application overrode those key concerns. But what he does go on to say is that he feels that given there are children on the site, and that those children would be affected by their immediate removal from the site, he was willing to grant a temporary consent for 3 years to allow the applicant to find an alternative site to move his accommodation to. So the inspector has granted a temporary consent for 3 years and 3 years only, but very much agreed with the council in terms of everything else. And he says it is, in my judgment, the matters in favour of the proposal, when added together, do not outweigh the substantial harm to the green wedge, and accordingly very exceptional circumstances to justify the development do not exist, albeit he has granted a temporary consent for 3 years.
Okay, anything else on the report you'd like to note, Marcus?
No, that's it.
No. Any member? Happy we note that. Okay then, appeals is done, thank you. Agenda item 9 on page 31, that's trees. Anything to add, Marcus?
No, nothing to add, Chair.
Nothing to add on the delegated list either?
No, nothing to add, Chair.
Members happy? Yeah. Okay, thank you. Over onto page 10, I think this was Councillor James who asked for this. This is a letter from the Minister for the Environment regarding the clarification of national planning policies that apply to onshore, unconventional gas and oil development, which is found on page 32. Marcus, would you like to lead us through it?
Thank you, Chair. Yes, this letter, which came out in late summer from the Welsh Minister, basically clarifies that, and some members may recall, I ran through a document produced by the Department of Energy and Climate Change nationally called Onshore Oil and Gas Exploration in the UK, the Regulation and Best Practice. I did have a session with some members about that document, and you'll recall at that session we did say, obviously this, strictly speaking, only relates to England, although the key tenor of it does affect Wales as well, because many of the issues within it are not devolved issues through energy generation. And basically the letter that's come out from the Welsh Minister is helpful in as much as it explains that the guidance produced by the Department of Energy and Climate Change has now got a Welsh version and is exactly the same but takes account of Welsh organisations, and just points out the various issues which we went through when we did that training, that what the stages are for developments, what the national planning policy background is, what can be considered through the planning system, what the regulatory roadmap is for developers within the government processes, gives some advice on whether environmental impact assessments are needed, and obviously deals with issues relating to restoration and aftercare of sites, which is actually quite useful at the moment, given what's happened with open cast sites recently, quite close to this council. But it is a useful document, and one which clarifies that this very important and useful document from Department of Energy and Climate Change applies directly to Wales as well.
Bit of a cut and paste job, I think, Marcus. Anyhow, Councillor James was called it in. Anything to add to it, Councillor James?
I think I can agree with you, Chairman, in that respect. But I think it's. I recall when as the committee was asked to consider the test drilling sites, which were really referred to as fracking sites, and I had one in my area, and other members had as well. And the one thing that we were thirsting for at that time was clear guidance from the Welsh Government, and indeed maybe even a policy. And I think it would have been useful, but nevertheless, the committee has made its decisions, and we're in a position where we are. And I think that, to allude to what you said to, Chairman, I think this is not a policy. This is merely a route map to policies that could be considered to be appropriate for us to use. And in that respect, I think it is a useful document. And I just wonder whether, what will be the process for dealing with applications such as unconventional gas and oil development. And perhaps Marcus can advise how this will change, or will it change, the way in which we deal with applications by way of reference to this route map, if you like. Thank you, Chairman.
Thank you.
Thank you, Chair. Well, it does set out very clearly what, as a planning authority, we can and can't consider, and what parts of any proposal are relevant to the planning legislation, if you like, and the planning guidance, and what parts are controlled by other agencies such as Health and Safety Executive, Natural Resources Wales, or all the other various quangos and other parts of national government as well, because quite a few elements of that type of development would actually be controlled by the Department of Energy and Climate Change directly, rather than by any Welsh devolved powers. So it is useful in that respect, because it allows members to focus on the very specific issues. You will recall we had an application for test drilling in Landau some 2 or 3 years ago, which ultimately ended up in an appeal which was lost by the council. But I did feel at that time we were very badly advised by Welsh Water, who put in objections and then withdrew their objections, and basically just before the appeal was heard, pulled their flag down. And it makes it very clear in this document that I think we'd have had this document, we wouldn't have made the decision would have been taken differently. It spells out exactly what Welsh Water's role is, which is very limited actually in assessment of this, and puts the responsibility on other agencies. So it's useful in that respect. I think you're right in one regard. It doesn't actually set out a policy or a national policy for Wales in respect of this type of gas exploration or extraction. That is still, in fact, in England and Wales, very much not considered yet, although there is a sort of a general move that nationally that it is supported at the highest political level. There is no actual planning guidance which deals with it. So we're not really any further forward in that regard.
Can I just, Chairman, just thank you and Marcus for bringing the report, because I think, it is important for members of the committee, and perhaps for the minutes of the planning committee, which are probably more widely read, an opportunity to see that actually there is now this route map to the key policies that affect this process.
Can I thank you for asking to bring it, so we've had the opportunity of seeing it. Thanks, Councillor James. Any other member? Yes, Councillor Drysdale.
Not sure this is a question for Marcus, it might be one for our lawyer, but there's no mention in here of liability responsibility, but we've got a variety of public bodies being asked to give a view about whether a process can go ahead. But if there was then damage or injury, do we have any idea of where liability would lie? Would public bodies come into the frame, or would it be entirely the operators?
A very interesting question. As opposed to some other countries around the world, the rights to extract these gases and other items are solely governed and solely controlled and actually owned by the government. So no matter whose land it's on, these issues are actually owned by the government. I suspect it would be the company that extracts it, and it would be Health and Safety Executive who would pursue issues of damage and possible personal harm. It would be Natural Resources Wales that would pursue possible environmental damage. It's unlikely to be the council, because except if they breach planning, the conditions of their planning consent, but actually the powers that exist in respect of both the Natural Resources Wales and Health and Safety Executive in terms of personal injury and what have you are far greater than the powers that the council has in that regard under the planning system. That being said, I'm sure I mentioned the issue of the open cast mine in Margam and beyond, which is in Neath Talbot, and where they've had tremendous issues with trying to get the remediation of those open cast pits now that the pits have closed. And that issue has fallen fairly and squarely to some degree on the council, because the developer of those mines the owner has changed, and there's been all sorts of issues with the bond that was supposed to be retained and for remediating the land. Those issues would have to be very carefully considered if an application ever came in to formally extract gas or any other mineral from the ground underneath the Vale of Glamorgan. And I'm pretty certain now, given that's happened there, that Welsh Government is looking at that issue very, very seriously. It is a key issue which could lead to, in that particular case, a public bill of millions of pounds. So I think it's an issue which is still very high on the agenda and is being considered really at the very highest level. But to answer your question, to come back and answer your question, I think the issues of natural resources Wales would be, if there is any ecological or environmental damage, Health and Safety Executive if there's personal or property damage.
Yes, I think the lawyer would like to reply as well. Marcus, are you off?
Councillor Drysdale, just to say that this is not something that we've been asked as the legal department to look into specifically, but obviously it's something that I can look at to see if there's any information out there as to liability going forward. So I can certainly report back on that. Okay.
Okay. Any other member? Or are you happy? I think there is a recommendation that the members note the content of the letter and the associated regulatory roadmap. Members happy? Yeah. I think that's pretty unanimous. Is that correct? Yeah. Yes. Thank you. Okay then. Moving on then to page 86, onto the planning applications. Pant Wilkins Stables at Aberthin. I understand there's some late reps with that, Marcus. Would you like to read this through?
Yes, thank you, Chair. The late representation is actually just an amended condition number 2 from your officers, because amended plans were submitted at the last minute by the developer at the request of the council. You may or may not remember this site. I'm sure some of you will. We have been here on numerous occasions, actually on site visits. This application originally came before you back, I believe, around about October 2003, where it was recommended for approval subject to a legal agreement, which dealt with issues of tying the house to the land and other issues to do with the fact that it was allowed as a rural business dwelling. The negotiations with the developer or the owner's agents and our own legal department over the signing of the Section 106 agreement proceeded from that point. Unfortunately, unbeknown to us, and it only became relatively recently known to us, that the actual owner of the site proceeded to go and build the house in any event, even without the planning permission in his hand. I think it's probably not unfair to say he has an element of track record for doing this, but no pun intended, absolutely. In any event, what has been built is very, very, very similar to what you considered last time. The only real difference is one chimney has actually not been put onto the house. It had 2 chimneys at either end. One chimney is now not on the house. And actually the amended condition just deals with the fact that we asked them to make sure the plans matched what was actually built. So albeit we're not particularly happy that he's gone ahead and built it, there are no other issues here other than the fact we have to change some of the conditions, and we have to recognise the fact it's now what we call a Section 73 application, which is a retrospective planning application, and that has to be done before any legal agreement is signed. So this is why we're bringing this back to you as members. There is one other issue which is not really relevant to this committee, but I think is worth pointing out, is that there is a footpath which crosses the site. If consent had been issued for this house, the applicant could have applied to formally divert that footpath, and that would be the process. As we all know, there have been issues recently about this, but the process would be when the consent is issued, the developer would then apply to divert the footpath to ensure that when the house is built, the footpath had been diverted, or at least the process was well underway. In this particular case, because they haven't had their consent, they've built their house and they've actually obstructed the footpath. That matter is with our colleagues in legal and footpaths at the moment.
Yes. Councillor Parker?
Yes, I mean, we all understand the problems with this site. There is a log cabin there, and I note there is a condition on the 106 that it could run on for a short while after the occupation of the house. Perhaps Marcus could explain why that is put in rather than that the cabin should be removed prior to occupation of the house.
I think, to be fair, the house is not actually can't be occupied yet. It's still construction going on. We recognise there will be cases when you're moving items back and forth between what has been the owner's property. They do sometimes need time to alleviate those issues, and I think we're just being reasonable. I appreciate that in some cases councils may feel they don't want to be reasonable with, but I think actually in this particular instance it would serve no purpose. We are getting the cabin. The cabin will be removed once the house is occupied, and we will be monitoring the situation very closely. We have monitored this one. It is through us that we've picked up, through your officers, that we've picked up the house was built, albeit it took a few months. But to be fair, your officers are working under quite a lot of duress at the moment with the number of enforcement complaints we do have. So it has been picked up, and it's fairly safe to accept that if the house is then occupied and the log cabin hasn't been removed, we will be chasing its removal.
Okay. I think it's been moved by Councillor Jeff James, but did you want to say something, Councillor Penrose?
Thank you, Chair. I make a general question to Marcus rather than on this specific case. But as a planning committee, I think a lot of us feel that retrospective planning flies in the face of the planning system that we try to implement. This seems to be very much in the air at this part of the Vale of Glamorgan, because I can think of two other instances we had it. But for the planning committee, what are the tools we have that basically to deter this? Because to me, every time you agree to a retrospective, you condone somebody else doing it again somewhere else. And I just wondered whether there are anything that we can implement to try to not seem to be condoning unauthorised.
I think this is slightly different, though, isn't it? He's had planning. It's just that he hasn't signed any 106s. Is that right? We've given the planning permission, so he had that, but because it's failed because he hasn't signed those 106s. Is that right?
Yeah, I think that, to be fair, this is a slightly different situation to just a straight retrospective application. The application was in for a number of years. He came to committee, his application came to committee, and members decided to approve it, subject to him signing a legal agreement. The consent isn't issued until he signs that legal agreement. But unfortunately, while those discussions were going on, the gentleman went ahead and built it anyway. That being said, that is completely different to somebody who's just doesn't ask a question, ignores it, goes ahead and builds a house in the countryside, for example. That would be a completely different kettle of fish to this one. And I think the point is that there are many different shades of retrospective planning applications. We have to, as yourselves as members and us as officers, have to recognise that the way the government has set up the planning system and the way it's existed since 1947, it is not unlawful to build without planning permission. It is only unlawful when an enforcement notice is served. So, yes, you can be in breach of planning control, but you're not breaking the law. That being said, if something is unacceptable, we will serve an enforcement notice if councillors authorise it, and at that point something will become unlawful, and we have other options open to us if the person doesn't comply with that notice, that enforcement notice, such as stop notices, or taking the person to court or serving an injunction. So there are powers out there. It's just that in some cases, procedurally perhaps the person is wrong in what they've done, but it's not. This isn't the greatest breach in the world, given that we've already authorised as a committee this development.
Could I just add to that, the condition that wasn't met when the house was commenced being built, it has been No. Placed as a condition, unadulterated, no changes.
Yeah, one of the key issues was that we wanted the levels to be agreed, and obviously we couldn't agree it that retrospectively because the house was built. But your officers have been to the site on 3 separate occasions. The levels are fine. It is absolutely. It accords with what we would have asked for if they'd have submitted the details. So that condition is now no longer necessary. That's been taken off.
Councillor Gwyn Roberts.
Thank you, Chair. I'm just talking in general terms, as Councillor Penrose's query was. I appreciate it's not illegal, so therefore you can't fine anybody building without planning permission. And I also recognise that it's rather than a black and white issue, it's a continuum with certain levels. But at some point there is going to be somebody who has some contempt for the planning process. And I just wonder if there's any scope in terms of the planning charge system, such that retrospective planning permission is charged at a much higher planning fee rate than anything else. And I just wonder if that's one tool we might be able to use.
Marcus.
Thank you, Chair. This has been suggested to Welsh Government on many occasions, actually, and they usually dismiss it. The only situation where it does actually occur now is where an enforcement notice is served on somebody. If they want to try and authorise what they've done through an appeal, it's called a Ground A appeal, and basically it grants planning permission for something which we've served an enforcement notice on them for. And to do that, they have to pay a fee to us as a council, and they have to pay a fee to Welsh Government or the planning inspectorate, so they pay double the fee. So that is a way of the Welsh Government has introduced of, if you like, penalising somebody if they do something without planning permission. It is only double the fee, but it is a way, that's the only time where that situation exists. If they apply to us and it is ultimately acceptable if they change it or do something else, then they only pay the one fee, the same fee as everyone else.
Okay. Well, it has been moved by Councillor James. I haven't received a seconder yet. There we are. Councillor Val Hartree seconds. It's a recommendation subject to the relevant persons entering into a Section 106 legal agreement and undertaking to include, I think there are 9 necessary planning obligations. So that's what we're... those 3. Sorry, 3 planning and then 9 conditions. So that's what we're approving. Are members happy to approve this then? Can we show a hands, please? That's just for the recommendation. So that's 15 for. Any against? 1 against. Any abstentions? No abstentions. There you are then. That's clearly carried. Thank you. Over to page 104. The old carriageway stables at Hensel. Marcus, anything to add?
Yes, thank you, Chair. This is an application, quite an interesting application. It's for a eco-centre and visitors and education building on a site where there has been quite a big stable sited for many, many years, and actually a consent exists for an even bigger stable building. The building itself is designed to be very, very sustainable in terms of its building credentials. It is intended to attract school children and people interested in eco building. It has been submitted with a full supporting business plan. The site actually is in the countryside and is adjacent to the historic Hensel Park, but it is completely surrounded by the golf course and hotel buildings. And if you look at that plan there, you can just see the old ward blocks, which are all now individually designed houses, just on the top corner. And actually, to get to it, you drive down one of the accesses to the hotel and golf course. Your officers have taken quite a lot of time to look at this, and obviously there are policies which support and policies which don't support development like this in the countryside. But overall, given the way the developer has worked with the council's tourism and education departments to put forward information, given the way they have supported it with business plan which shows a sustainable future for this building in the wider business sense as opposed to sustainable in terms of eco-development, Your officers are recommending approval subject to conditions and feel this would be a valuable tourism asset for the area.
Councillor James.
Chairman, I'm happy to move the recommendations as before us.
Thank you. Second, I've got Councillor Bob Penrose as second. So thanks for that. What we are doing, we're approving this application subject to conditions and a legal agreement.
Yeah, there's no legal agreement.
There's no legal agreement apparently.
So
It's just recommendations, yeah.
Subject to the conditions.
Yeah. So we're approving it subject to these conditions.
Sorry, it's a recommendation.
Yeah.
We're not
We all know what we're talking about, but the legal officer gets himself tongue-tied here. Right, okay then. So those in favour, it's been moved and seconded. That is clearly carried unanimously. Thank you for that. Moving on then. We go to the Laurels in Lanquinian Road, Aberthin, Cowbridge, which is on page 124. I think this is for refusal, is it, Marcus?
Yes, thank you, Chair. Yeah, this is an application for 3 dwellings on a site along Lanquinian Road. Lanquinian Road actually comes out of Aberthin and heads towards the Pant Wilkins stables, which we were talking about. It is quite a rural area, albeit that this site is right on the edge of the settlement boundary. You'll note from the planning history that previously a consent has been granted for a single dwelling on this site, so as a replacement dwelling. Your officers have looked at this scheme. It is obviously an intensification of what was originally proposed. We do have real concerns about it from the point of view how it will appear within this very much edge of settlement location, where dwellings tend to be set in much larger gardens and are actually set against the backdrop, obviously, of the special landscape area as well. We also have real concerns because Lanquinian Road is a very narrow lane, country lane, and the parking which is proposed really will lead to probably quite a degree of on-street parking on Lanquinian Road. And anyone who's driven down Lanquinian Road, it really is a narrow country lane which will cause severe problems. You'll see there that in terms of parking and manoeuvring, vehicles are going to have to reverse out onto that road because the site is quite restricted in terms of how they've tried to cram 3 dwellings on there. So we just recommend a refusal over development, effect on the edge of the settlement, and obviously possible effect on highway safety.
Councillor Parker.
Thank you, Chair. No, I would support the officer's recommendation. The little lane that runs up to Stalling Down is particularly steep and at this point is very, very narrow indeed. It is clearly gross overdevelopment. It does affect the appearance and character of the Aberthin area, and I would support and recommend the refusal.
Okay, that's moved and seconded by Councillor James. Any other member want to move to a vote? Yeah. Okay, then the recommendation is to refuse this application as set out in the report and mentioned by the planning officer. Those in favour of refusal, please show. Well, there you are. That is clearly carried with a majority decision. Thank you for that. Moving quickly on, we're now on to page 138, Cruskeen Lawn, Love Lane, Lamblethian, Cowbridge. This is to approve this application. Marcus?
Yes, Chair. This is an application for basically to amend the design of an existing house by knocking down what is currently a garage and bedroom above, by building a new dwelling in the location where the garage was sited and then building a garage and bedroom on the other side of the house that is proposed. So basically that's what's proposed. That's the house that's proposed there. If we go back slightly, Ian, if we can.
If this helps, Marcus, I think the local member's going to ask for a site visit. Right. So shall the local member speak?
Thank you, Chair. Yes, there is a lot of concern both with the to Cowbridge Lamblethian Town Council and the other 2 ward members. The little plan that was shown up for the access, basically the access as shown on there doesn't work in our view. We're still waiting for highways to comment on it, and therefore I am requesting a site visit so we can see the difficulties, particularly onto a narrow lane, with four or five cars coming out on, again, something which is a very difficult junction. So site visit would be requested.
What, with a officer from the highways?
With
present?
highways, most definitely.
Okay.
If you look on there, there are two cars shown in front of a garage, which is shown incorrectly on the plan I've got, because it actually shows two garage doors, not one. But it is quite impossible to open the garage door, the car doors, and how you would manage to reverse out in that position is beyond belief. So we do need the highways officer there to explain that.
Okay. Members happy for a site visit? Yeah.
Yeah.
All those in favour? That's clearly carried. Thank you. It'll be a site visit then. Yes, okay, we're losing Councillors Val Archery and Keith Hatton, who have previous engagements. Thank you for that. Right, on page 153, and I think this is subject to late reps as well, we've got 10 Park Road, Penarth. This has been a history of planning and a number of site visits, if I recall, Marcus.
Yes, thank you, Chair. Yes, not related to this, and but yes, related to another development for a single dwelling. Yeah, this is an application for a screen fence at the rear of the property, 10 Park Road. A variation of condition 3 is proposed, which requires the fence to be no higher than 3 metres at the sides of the fence. Basically, and we have got 2 objections as well, further objections from the neighbours to the rear. The applicant has proposed this fence partially to enclose a tennis/games area they have at the back of their property, or building at the back of their property, and partially because they are unhappy about an extension that was built to a property to the rear, and they feel which overlooks their garden. Your officer's view in terms of the overlooking clearly is we approved the extension. We don't believe there is an issue of overlooking, but that being said, we understand that the fence serves a dual purpose and is intended to be to stop games and stop tennis balls and whatever from flying over the fence. So we have entered into negotiations with the person who made the application. It was originally proposed to be 6 metres high, which was seen to be completely unacceptable. The developer has accepted 4.5 metres high, which is approximately the height of Leylandes that did exist at the rear of the property previously, although there is some debate about their height. I have seen photographs of the Leylandes in place, and it would be difficult to say they were any lower than 4 metres. They were quite high Leylandes. So on that basis, your officers have taken the view that 4.5 metres in this particular case at the back is acceptable. The land is slightly lower in 10 Park Road than it is in the property to the back. At the sides, the fence is no higher than 3 metres, not 4 metres as referred to in the report. It is 3 metres, which is why we put the condition requiring it be no higher than 3 metres at the side. So basically, your officers do not consider that that is the maximum height we could allow while ensuring that there is no harm to the conservation area.
There we are. I think Councillor Gwyn Roberts would like to speak. Thank you.
Thank you, Chair. Just for correctness, I should say I considered this 6 metre fence as a Penarth Town Councillor some time ago, but I approached this with an open mind and significantly different anyway in what's being spoken about. I think when you start comparing a 6, I'm afraid I'm a bit old-fashioned, and for me to be able to visualise things, I've got to put it in old money. A 6 metre fence is pretty well 20 feet high. 4.5 metre fence is 15 metres high, and 3 metres is 10 feet high. I think, to be honest, that given that this is a conservation area, delicate area, I think the objections of the neighbours are absolutely right. It is the most unneighbourly form of development, and I think it will be intrusive. I appreciate that it may not now be visible from the highway. I think it will be visible from the pathway down to the beach. I would suggest a move that we actually put a condition of 3 metres high along all sides of the fence, and I suspect the neighbours will not be happy with that, but I think that would be a reasonable compromise, so I therefore propose that as a condition.
Yeah, do you have a seconder for that? There you are. Councillor Rhiannon Birch has seconded it. Any other member? Councillor Penrose.
Yeah, I support Councillor Roberts' viewpoint, and perhaps ask Marcus, if we state that being overlooked by the other development which we afforded planning isn't an issue, and it's purely to contain balls inside the tennis court and sports area, why aren't they developing it with a mesh fence, as most people do on tennis courts, instead of an actual boundary screen?
It is actually a mesh fence, but it's a denser mesh than you normally get. I don't know if you look at the objections of the neighbour, they make a very valid point that if you stand very close to this fence, you can actually see through it, the fence that's proposed, and they question if it's going to actually do what the applicant wants it to do in any event. But just for clarity, it is a mesh fence. It's just a mesh fence with a denser mesh on it, so that it does provide, it affords at a distance some opaque, it stops views through, basically. There's a photo, the photo which has got Edwards Sports Products on page 153. Basically, it's not a very good photo and it hasn't reproduced very well, but basically you can see when on the colour version of that photo that you can still see through that fence. You can, at a certain point, you can sort of see the light of the trees coming through beyond. So it is still a mesh fence.
Yeah, I mean, unless they're using smaller tennis balls than I used to play with, I don't really see the point of a dense mesh, I mean, it's just the retention of the ball, surely, if it's a tennis court.
Well, I think that we've got a recommendation to approve it, subject to an additional condition that the fence be 3 metres for the whole perimeter of the boundary of the property. Is that how you see it, Marcus?
Yes, Chair. I mean, if members wish to do that, actually condition 3 can be amended. It says, notwithstanding the submitted plans, the fence to the side elevation shall not exceed 3 metres above existing ground levels. That could be changed to the fence in total shall not exceed 3 metres above existing ground levels.
Are members happy with that?
Yeah.
Okay then, so we move to a vote then. All those in favour with this alteration to the condition 3, that it be no larger than 3 metres? All those in favour?
13.
That's 13 for this additional condition.
Yes.
Against? Councillor Marnie is against. Thank you. Any abstentions? I didn't see any. No? That's all. Yeah. Thank you. That's carried, clearly carried. The Grange St Bride's Super Ely on page 162.
Mr. Chairman, can I say that the local member, Councillor Roddy Trahan, has asked me to ask members if they would agree to a site visit, because obviously this is causing a great deal of concern in the ward and to the community council. So
Okay.
I'm happy to move a site visit.
Yeah. Members happy to have a site visit? All those in favour? Aye. That's clearly carried. Everybody in favour. Thank you for that. Okay then, over onto page 188, which is the Ports Office, Atlantic Way, Barry, former Steamers Trading Co., the Esplanade. Is that all one word, Marcus? It's on page 188. Is this the solar panels, Marcus? Yeah, thank you.
Thank you, Chair. Yes, this is an application for the erection of a 10 megawatt solar voltaic system on land which is currently part of Barry Docks. You'll see that it covers approximately 16.5 hectares and has been used or formerly used for recycling inert waste, but it's mostly unoccupied now and is covered with scrub land. If you looked out of the docks office, it's behind the very big blue buildings. You can see directly across the docks. It is very well screened from most of Barry. It is likely there will be some views of it from the island itself, although the applicants have suggested additional planting and landscaping to ensure that any views are limited. And clearly the condition of the land now is not particularly attractive, so the proposal probably is this is a better place for one of these developments than the open countryside, which we've had quite a lot of recently. So your officers are recommending approval.
Any? Yes, Councillor Williams.
Move the recommendation.
I'll second that.
Yeah. Okay, then we're moving to approve this recommendation. Is everybody happy? Yeah. Can we vote our hands in favour of this recommendation to approve? That's 13. And those against? Councillor Kevin Mahoney is against. Thank you. So that's clearly approved. And the last one is the former Steeders Trading Co. on page 213 on the Esplanade in Penarth. Anything to add, Marcus?
Nothing to add, Chair. This is an application for a sign on the front of the building. The photo there aptly shows it. I am told that now the unit is occupied. The sign looks very much in keeping with what's along there. This application was called in by the local member, but your officers are recommending approval.
Right, okay then. So, and seconded. I think Councillor Roberts wants to speak and Councillor Mark Wilson wants to speak.
Just in support of the recommendation as well, Chair. I think this is quite a tasteful. I mean, it's obviously a subtle matter of taste, but it's quite a subtle thing, completely in keeping with the beachside restaurant. My only slight reservation is that the lower lettering is perhaps a bit too thin, so it looks a bit like graffiti. But other than that, I would support the recommendation.
Okay, Councillor Wilson.
I just think it's very much in keeping with what the development is, and I think there's plenty of other signs on that which I feel would actually help in this, because you know there's lots of different kind of signage in there and that makes it interesting.
Well, it's not the most beautiful of buildings, is it? But this, yeah, and the sign looks okay, but there you go. It's the taste is in the beholder, is that what they say?
Yeah.
Yeah? Okay then. I think it's to approve. We've had it moved and seconded. Is everybody happy that we approve it? Yeah. Those in favour? Well, that's clearly carried. So from me, in the chair, can I wish you all a very happy Christmas and a very happy and prosperous New Year.
Thank you, Chairman.
And we'll see you on the 15th of January. I have to say that something that will come before you on the 15th of January, which we need to just note, is that I think I'll let Marcus deliver it because it's an additional site visit.
It is likely we'll be bringing the development of 70-odd houses in Colwinston to the meeting in January, so we will probably be putting that on as a site visit in addition to the two we're
already doing. So don't be shocked when it comes on the agenda. Okay.
Thank you.
Thanks for your attendance.